And call the meeting to order. Have a roll call, please.
Ryan Crawford,
Present.
Leonard Knapp,
Here.
Harold Parit.
Here.
Eula Simeon.
Here.
Lenore Feeney.
Here.
Jason Hanneman is here. We have a quorum.
I'm going to ask we observe a moment of silence. Pledge allegiance to the flag of the
Nation under God, indivisible, with liberty and justice for all.
We move into comments, items on the agenda. I do want to take a moment to acknowledge that today, the 100th cadet class for Louisiana State Police is graduating and being brought into the rank of trooper. A little over 50 men and women who are making that move today. We want to send our congratulations to them for making it through a very tough academy and where they've learned a lot, and that we know and hope that they will put into practice as state troopers for the state of Louisiana. We have one request that I'm aware of to address the commission on items on the agenda. It's by Mr. Burns, who wants to talk about the minutes. Step forward, identify yourself, and do try to limit your comments to 5 minutes or less. All right, great. I didn't think so, but just in case.
Thank you, Mr. Chairman. And I think, well, it's Robert Burns, Sound Off, Louisiana. And as I think all of you know, I rarely do this. It's probably about the third time. But I did feel compelled to do it this time because, as everyone is aware, in the last meeting, we came in for a brief period of clarification with regard to, the executive session was broken up to come in for a clarification. I firmly believe that the minutes ought to reflect, and had I known what that clarification would have been, I certainly would have gotten my camera rolling to have recorded it. Obviously, I don't, but we're talking about 3 prospective recording devices having been left in this meeting during an open session. All 3 that were acknowledged are either present or past officers holders of the Louisiana State Troopers Association. We're not talking about rookies. We're not talking about people who just dropped in here. We're talking about veteran attendees of these meetings. And I believe it would only be responsible. And I understand there was a 4th person that also left a recording device in. Since that one was not called out publicly, I'm going to go on what I've been told. But if so, I think that should be also reflected in the minutes. My thought is, as much as you drill that home, Mr. Chairman, and you do a good job. It's inexcusable. And my personal opinion is it was not an accident. I know the inquiry was made as to whether the potential recording devices were activated, and all 3 individuals said they were not. Really hope we can take them at their word. Hope a lot of things with LSP that we can take things at their word. So a lot of times it's turned out not to be the case. So that's my only public comment, is I believe that the minutes do not reflect that. In my opinion, there should be a request to amend the minutes to so note that episode. Because as far as I'm concerned, it was part of the official meeting. I realized that when we were called back in, there was no formal calling the meeting back to order, but I think it was an extremely significant point of the last meeting and potentially could affect the hearings or the matters that are before you today, because I think everyone knows what was being discussed in this room when that executive session was taking place. And I know that if I had done something like that, I would be expected to be read the riot act and quite frankly thrown out. And I think you would have been justified in doing so. So with that, I'm done, Mr. Chairman, and I would make the suggestion that the minutes, if they don't already contain that, be amended to reflect what transpired in the break during the executive session. Thank you so much for the opportunity to speak before you.
Thank you for your comments, Mr. Brown. Did we receive any other requests, Mr. Hanneman?
We do not.
We'll move on to the business items. Which first item of business is consideration of the minutes. Do we have any motions to amend the minutes?
Mr. Chairman, I think that occurred while we were in executive session, if I'm not correct.
It did.
And we
We did not break executive session. We did call people in to get them to remove their devices and identify who they were, but it was technically, I guess, during executive session.
So my thought is that really by having this brought to our attention today, that this occurred, that probably should be reflected in today's minutes as a notation that what did happen. I mean, I acknowledge that it happened there, and I was distressed about that. But the minutes themselves, I think, should stand as they are, and I would so move.
So if we have a motion to adopt the minutes as written with the understanding that today's minutes would reflect the issues that were discussed in the open public session of the meeting. Is that correct?
That's correct.
Do we have a second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. Thank you for your comments, Mr. Burns. All right. The next item, business item, is consideration of a request from the Office of State Police for the 2-year reauthorization of 15 part-time WAE positions. We have a representative of the agency to answer questions. Who would that be? Would you come up and identify yourself, please?
My name is Elena Collins. I'm an HR manager. Good morning.
Why don't you tell us what these WAE positions are for?
These are trooper WA positions. And I apologize for not being more prepared. But I do know that these are 15 WAE trooper positions. Over the last year, State Police has lost over 100 full-time trooper positions. And as we know, 51 cadets are graduating today. So these trooper positions are just to assist in the interim until we get these troopers that are graduating trained and ready to do their jobs, basically.
Anyone have any questions? Yes, sir. Commissioner Knapp.
How many of the Louisiana State Police positions are now held as WAE positions on the total force? Right.
I'm sorry, I'm not certain. I don't have that number.
Okay. Yeah, if you could get that, I'm just interested in how many positions are we're having to hold in this WAE positions.
Sure.
With that, I would Chairman, I would move that we approve the WAE positions as requested.
Would you accept the substitute motion that we defer this to the June meeting?
Oh, okay. Sure.
Mr. Chairman.
Yes. Commissioner.
Yeah, I mean, one of the issues is if the appointing authority is going to have an item on our docket, they need to be here to present and be prepared to answer questions from this body about the information that they're requesting on here. This is unacceptable to not have somebody here from the appointing authority to present this to the commission and to answer our questions. I mean, I know it's standard. We do this on a regular basis, but we're not to be taken for granted that we're a rubber stamp up here either.
Yes, sir.
So, thank you.
Just want to point out, as you mentioned, that they are at the graduation. And that's the
Understood.
reason no one is here today.
Right. They should have put it on another month's docket then.
Yes, sir.
So it's been moved, and I take it second that this be deferred to the next, any other discussion? The next meeting. All in favor?
Aye.
Any opposed? Item on the agenda is consideration of a request for the Office of State Police in accordance with State Police Commission Rule 12.5 to place Trooper Garrett Yetman on suspension without pay pending criminal proceedings until this resolution of these criminal charges, or there is no longer a need for suspension. Is there a representative of the agency available to answer any questions?
Good morning, Michelle Gerard for the Office of State Police.
And is there anyone here on behalf of Trooper Yetman?
Lloyd Falcon on behalf of Trooper Yetman. Trooper Yetman is with me.
Is there any opposition to this proposal? Falcon?
There's opposition to the proposal with the exception, no opposition to the specific proposal, provided we be allowed to use his earned annual leave K time and a half K time. And I understood that there was no opposition to that occurring, and that be the case, we would be agreeable to that.
If Trooper Yetman would like to use his leave voluntarily during the period of suspension without pay, there's no opposition to that. At the time he would exhaust that leave, if that occurs, then the suspension without pay would continue on, is my appreciation of it.
We have 900 hours, so we hope that we can resolve this before he would exhaust 900 hours of leave.
We would hope so.
But the way the criminal courts work, maybe not.
So basically, there's no opposition with the proviso that Trooper Yetman be allowed to use his approved leave during the suspension. Subject to whatever might happen later on.
We'll deal with it in 900 hours.
Any motions?
So I make a motion, Mr. Chairman, that Trooper Yetman be able to use his accumulated leave during the suspension period until it's exhausted, and then he would be placed on leave without pay.
A motion and second, any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Thank you, Your Honor.
Now, we've only been in session now for about 15 minutes, but I'd like to take about a 10-minute break. Any opposition for any commissioners?
sufficiency and the number of people that we have in the chamber today as witnesses, I'm going to make a motion that we flip on the agenda items 4 and 5 and take item 5 up at this time.
We have a second.
Second.
All in favor?
Aye.
Any opposed? Okay. We'll move to item 5 on the agenda in the matter of Albert Paxton, Department of Public Safety and Corrections, Office of State Police, docket number 21-258-RV. Menon Campbell representing Mr. Paxton and Laura Hope. They're representing the Office of State Police. We're here for a public hearing. This hearing at this time is limited to the issue in the appeal related to the sufficiency of the notice. As appellant, I think.
Your Honor, and we don't have any witnesses. We only have a brief argument. And that is that those rules are set out to protect the troopers and to give them fair notice in anticipation of their interviews with internal affairs. And that the notice didn't have a date, and it referenced emails that could go back potentially 13 years in Sergeant Paxton's career. And for those reasons, we asked that it be rescinded on the fact that the notice was defective because it was insufficient, Your Honor.
Yes, good morning. We would just like to establish that Mr. Paxton did not suffer any adverse impact from the administrative notice that was issued to him. No testimony has been offered here today to establish that he suffered any adverse impact. And also, we would ask that this commission not rule that there was a violation in connection with the appeal with a full notice. And that the commission would hold similarly to the Woodward decision, since this notice was issued prior to the commission's decision in that matter.
Now, you do agree there was no date in the letter?
Yes,
No date as to the emails that was.
no date was referenced to the emails, yes.
If I may, there's a stipulation. Do the parties intend to introduce the exhibit? And is there a witness that you still plan to call?
I do not plan to call Sergeant Buckland because we do plan to stipulate to the administrative notice.
You want to release Sergeant Buckland?
Sure.
He's here in the event the commission had any questions for him regarding any practices currently.
That's what one of the other commissioners does. We want to focus on the practice at the time of that
Absolutely.
letter.
Understood?
Okay, so we can release Sergeant Buckland, and then the one stipulated document is the letter that you're going to introduce
Yes, ma'am.
and bring up here.
Yes,
Okay.
I'd like to offer file and introduce it at this time.
Okay.
I guess I do have one question. I don't know if it's for your witness or if it's for you. So any explanation of how this letter was issued without a date referencing the,
I'd have to have Sergeant Buckland up here to answer that question.
you can answer that question.
Yeah.
Sergeant Buckland, would you raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
Good morning, everybody. I believe your question was,
How? I mean, the rule clearly requires that a date of the alleged incident be provided in the notice. You agree with me, right?
yes, sir, and I have no argument with that. Just for like historical practice, whenever we would draft letters in IA at the time, we would try to compile information into it that consists of whatever the allegation was, without getting too far into the details of everything, not necessarily specifically intentionally trying to withhold information, but just trying to relay whatever the allegation was to move forward. Whenever the first appeal of this nature kind of came about, we shifted that practice, revamped the rules, looked at everything, and started implementing the date and time of the factual allegation that was levied against the employee to try and better fit the actual notification letter practice.
Do you agree that Albert Paxton had been employed with this agency for what, 13 years?
Yeah, yeah, I don't have any reason to say he wasn't. Yeah.
So at least based on this letter, it's gonna have been emails in his first year of his employment.
I'm sorry, would you ask the question again, please?
Based on what's contained in this letter, these could have been emails in his first year of employment that you referred to.
Yeah, there's no time frame, so yes.
How could Sergeant, how could Trooper Paxton, was it Sergeant?
It is Sergeant.
It's Sergeant.
I'm sorry. How could Sergeant Paxton know what to prepare for with this letter?
I mean, prior to his actual interview, I did reach out to him to schedule an interview with his wife, and I relayed that it was in relation to emails that were sent from him to his wife, which is why we interviewed her as a witness, as well as during his interview, I was able to provide him documented
That's not
accounts
how
of
you prepare for the
prepare for the interview. He would have to go back and look through his emails and see what he had sent to anybody outside of the agency would be the only way that he'd probably be able to prepare, I guess.
over the course of possibly 13 years.
Yes, or as long as his career was, yes.
Yes, yes, sir.
Did you know the dates of the emails that went out at the time that you were concerned about?
We knew the dates of some. This information stemmed from a previous administrative investigation. So we didn't know all the dates, and I don't know the dates off the top of my head right now, but through the course of another previous investigation, it was discovered that there were emails sent out to his wife, or at the time, technically, specifically, it was emails sent out to a wife, which had, an email that had his wife's name. We didn't know factually whether or not he was sending it to his wife. It could have been his personal account, but we didn't know that at the time. It was just to I don't want to use his wife's name, but it was to his wife's name's email account. So we knew some of the dates, but we also did we technically did, it was at least 2 other OTS searches for additional emails that were sent out. So we didn't know all of them at the time.
Chairman, so the emails that were sent out, they were sent out through the state police email system from
Yeah.
Sergeant Paxton?
Yes, sir. It was from his state issued
Right.
departmental email, correct, through that system to an off-server personal
So-
private account.
So when you send an email, if you yourself send an email out through the state police email system, is it dated?
Yes, and how it can come back from OTS, it'll come up, it'll create like a separate folder and it'll show you, it'll look just like a sent box and outbox.
Right. I mean, just
Format,
like my
same thing.
business, if I send an email out, there's usually a date and a time even
Correct.
as to when the email was sent. So that's why I'm a little perplexed as to the emails have a date on them. They probably even have a time on them. You can probably tell if they've been opened or not
Mhm.
even. I think reading through the notes, I think
Yes.
there was some stipulation in there about they could show that they had been opened. So just concerned about why the information was readily available, why it wasn't put in the notice.
And the answer to that is that was just how I had done it for the longest time, at least from my time going into IA up until recently when we made that change. So it wasn't anything, I would never say it was anything malicious towards anything. That was just how the practice was. You try to insert the information what we have at the time without adding all the information. Otherwise, it would be you don't want to create a 3-page letter trying to notify somebody. But now the practice is we are adding the date, and I specifically make sure every time we generate a letter, I want to see the date and time of the specific allegation levied against the person. And I try to repeat that as much as I can in the office now to kind of prevent this from happening again.
And what's your tenure with the state police? How long?
5.5 years with state police, a little over 5.5 years with state police. Actually, I think almost exactly 3 years in internal affairs now.
Thank you, Mr. Chairman.
No dispute over the way the rule read at the time this letter was sent, right?
No, not at all. No,
So
sir.
at that time, it required the date be provided to the trooper.
I mean, without reading it, I'm pretty sure it says the same exact thing of the date and time of the factual allegation has to be provided. So
Any other questions? Any questions for any of the parties?
No, Your Honor.
good.
I'm not entitled to that title, by the way. Do the parties rest?
Yes,
We rest, Your Honor, Chairman.
we rest as well.
Okay, we'll go into, we have a motion to go into executive session
So
to
moved.
discuss the issues related to misconduct, allegations of misconduct.
So moved.
So move. Second. Take a roll call vote.
Brian Crawford,
Yes.
Leonard Knapp,
Yes.
Harold Preet.
Yes.
Eula Simeon.
Yes. Okay, we ask everyone, including any potential recording devices, to be removed from the room. Do not wait in the little area outside of our meeting room here. Go out to the atrium area with your recording devices or potential recording devices. This time we'll entertain a motion to come out of executive session in the public meeting in the matter of Albert Paxton, docket number 21258 RV. Do you have any motion?
So move.
Moved and seconded. Any discussion? Take a roll call vote on that.
Ryan Crawford,
Yes.
Leonard Knapp,
Yes.
Harold Parikh.
Yeah.
Eula Simeon.
Yes.
We're now back in regular session.
Do you have any motions?
Chairman, in the matter of Albert Paxton, make a motion to grant the appeal and reverse the decision of the issue of the letter of reprimand in violation of Rule 12.13, which allows the commission to also proceed to Rule 1220 and reverse the penalty phase.
Have a second.
Second.
Any discussion? Only thing I would add is obviously there's some testimony that we heard relative to the time period of Sergeant Paxton's career with state police. There's no indication whether that email or emails was during his first year, second year, or 13th year. And from that, I do believe that there would be prejudice from the lack of notice in this particular case. So I plan on voting in favor of the motion based on that.
Mr. Chairman, just for the audience's sake, 12.13 is very clear, even though it had been mentioned, had not been a practice previously. It's very clear in here that a trooper is under investigation, including the dates of the alleged offenses and the substance of the factual allegations being made against the trooper shall be provided.
Any other discussion? All in favor of the motion?
We get a second, Mr. Chair.
Yeah, we got a second.
Okay. All right.
All in favor?
Aye.
Any opposed? Okay, the ayes have it. The appeal is granted and the decision is reversed.
Thank you, Mr. Chairman.
And Ms. Ellender, I understand that you'll be moving on to other, I won't say bigger and better things, but different agenda. We won't be seeing you again.
Yes.
Wish you well.
Thank you. Appreciate that. Y'all have a good one.
Brings us to item 4 on the agenda. In the matter of call Cavalier, Department of Public Safety and Corrections, Office of State Police, docket number 2157S. There are several motions that are pending, the first of which is a motion for contempt and for incidental relief filed on behalf of call Cavalier. We have parties present for that.
Yes, sir.
And I understand, Ms. Kraft, that you have 3 separate requests related to 3 separate, 2 witnesses and relative to the department. Let's break the arguments down one at a time, let the department respond, and then we'll move to the next one after that.
Not just the department, the individual.
And the individuals, I'm sorry, yes, and the individuals.
Right. I did not see anything from Mr. Turner. I don't know if I missed anything. Was there any filings?
There was only an email in which Mr. Turner had asked for an extension of time to obtain counsel and asked that his email be considered a motion to quash.
I don't have that.
That's all it says,
Okay.
but there is
I don't know if
nothing
there was
more.
any language in the email that I need to otherwise address, but
Gonna take the
Hang on.
department. I think we're gonna take Kevin Reeves first.
Ms. Kraft, do you want to look at the Jason Turner one after the
Sure,
Reeves
sure, sure.
argument?
Yeah,
Okay.
yeah, yeah.
Sit down.
Please.
Okay.
This is Jill Cratch and Brett Conrad on behalf of Mr. Cavalier, who is seated here to my right. At our last attempt, oh, sorry, yes, sir.
Louis Unglesby and Kevin Reeves are here, Your Honor. Gentlemen, thank you.
At our last appearance, to begin one of the hearings as it relates to Mr. Cavalier, we had properly subpoenaed Mr. Reeves, Mr. Turner, and documents from the Louisiana State Police. When we showed up for the hearing, Mr. Reeves, Mr. Turner decided not to appear, having nothing except some sort of email about I have a vacation and a deposition, I'm otherwise busy. And at that point in time, I moved orally, as I'm permitted to do, to hold the three parties in contempt, focusing strictly on Mr. Reeves for the purposes of our request for contempt and for incidental relief. I will note that yesterday I sat through a legislative hearing at which time Mr. Reeves was held in contempt by a committee of the Louisiana legislature. That will be a proceeding, I believe, to the House of Representatives for a full vote and imposition of a fine if it is passed. Here, the issue is much easier. Commission Rule 13.13 allows for the subpoena of witnesses and production of documents. Under 1313A, that is accomplished under the power and aegis of the authority of the executive director upon a request, which we did on March 30th, 2022, more than 15 days before the anticipated hearing date. Under subpart B, for all hearings conducted, no subpoena requested will be issued unless a written request, which we did for the issuance of the subpoena, is received in the office of the executive director no later than 15 calendar days. We sent our request on March 30th, 2022, and I would offer, file, and introduce the attachments to our memorandum in support of oral motion for contempt, among which is our original written request for the subpoena. The request for subpoena shall contain the name of the witnesses, street address at which they can be served, and a brief statement of what is intended to be proved by each witness. We complied fully with 1313. When we showed up here, and of course, Mr. Reeves was served. When we showed up here on, I believe, April 14th, Mr. Reeves was simply not present. 1317 of your rules allows for there to be contempt for refusal to appear, refusal to testify, and for false testimony. Under 1313B, in addition to any other penalties provided by law, any person who willfully fails to appear in response to a subpoena or an order issued under 1313, or who willfully fails to answer any questions, produce records, etc., shall be held in contempt or may be held in contempt by this body. The contempt proceedings are filled in the Louisiana Administrative Procedure Act, as we pointed out, and also the Code of Civil Procedure. This body has the power and authority not just to hold somebody into contempt, but also to fine them or to impose any other actions it deems fit. In addition to those powers and authority, one of the actions that this body is specifically empowered to undertake is to prohibit the offending officer or person from serving in any capacity with the agency for a period of at least 10 years. This is serious stuff. The person that we subpoenaed is the former superintendent of state police. This is serious business. The primary issue, at least as it relates to this initial request, relates to my client publishing a book. He was later terminated for speaking out. The evidence that I understood, frankly, from hearing 4 high-ranking officials within state police say yesterday was that they began having meetings as it related to Mr. Cavalier, whom they characterized as the quote-unquote leaker. Not anything relating to the death of Ronald Green or the officers involved in that, no, but as it related to this man. The reason we subpoenaed Mr. Reeves, frankly, is as stated in our original subpoena request, was for him to testify as to how it is we got to this initial disciplinary action of a 200-hour suspension for Mr. Cavalier for writing a book. The answer to that question was revealed in the report that was issued by state police, where they combined the issue of we're concerned about these leaks. We think Carl Cavalier did something bad. He spoke to the press about the killing of Ronald Green, and he also happened to write a book that we originally thought was critical of state police. I submit to you, if you cannot enforce your own subpoenas, as this body is charged with being the body overseeing state police, then these hearings mean nothing. Because what that means is somebody can come in and simply say, I have a vacation. I don't want to be bothered. I don't feel like I have to show up with a subpoena, regardless of the fact that we, the taxpayers, paid these people to serve as state police troopers. And when it comes to them subpoenaing, fulfilling their duties, and certainly testifying as it related to disciplinary actions initiated on his watch, he simply can just ignore it. That is why your rules under 1313 say if the information is pertinent, which it is. And under 1317, yes, sir.
Just briefly. So how is it that you contend that the discipline involved in the hearing we had scheduled arose under Mr. Reeves' command?
Because as I understand the testimony I heard yesterday and the original testimony before the legislature, what happened was within 1 week of Ronald Green's killing, they viewed videos. That was according to former Lieutenant Colonel Oliphant yesterday, Mr. Reeves, Mr. Oliphant, and others. The videos of the death of Ronald Green. At that point in time, they became concerned, fast forwarding into the spring of 2020 about quote leaks, which was Mr. Cavalier. According to the testimony I heard yesterday, they had meetings on a weekly basis, Mr. Reeves and the command staff, about Mr. Cavalier and the quote unquote leaks. That
Do
then
you
began.
believe that the discipline imposed in this appeal?
Yes.
This question.
Sure.
In this appeal is related to that.
Absolutely, 100%. And what happened was a cascade, and especially if you look at the report that they issued in their investigation, it was a cascade. They heard about some sort of book that Mr. Cavalier had written. That was at the same time they were looking at Mr. Cavalier for issuing statements to the media, for talking to the media, accusing Mr. Cavalier of being the source of quote unquote leaks about the Ronald Green killing. And at all that time, they came in and initially said, well, we're going to go after him for the book, and then we're going after him for the leaks. But all of them were tied together. And certainly, Mr. Simeon, I will tell you that in the testimony that I heard yesterday, all of that began with command staff meetings at which Mr. Reeves was the presiding officer in as early as the spring of 2020. So yes, sir, I believe it is absolutely tied together.
When was the book published?
The spring, late spring of 2020, and it wasn't exactly published. I mean, I know we're not here about the appeal, but the way that the book came into publication was Mr. Cavalier paid with his own funds a third party to print a book.
Self-published.
Right,
Yeah.
right. I
Happens
mean,
all the
he
time.
didn't get any kind of advance. Nobody paid him cash.
Sure.
He actually paid them to print the thing. And then on Facebook, he proceeded to market the thing. But all of this happened at the same time. State Police's reaction as it related to Mr. Cavalier, as you can read in the notes and the reports and all that stuff, is an absolute fear that he's writing about state police. What's interesting to me is nobody got around to reading Mr. Cavalier's book until way late in the ballgame, after they're sitting there bringing him in for internal affairs investigations about the leaks and all this kind of business that the command staff had decided would be their plan. And there's one, it's really funny. It's 2 sentences, 1 paragraph buried in the report where it says, somebody finally got around to reading the book and there's no reference to state police. So I submit to you, the information sought from Mr. Reeves is pertinent under Rule 1313. Mr. Reeves took no steps to properly quash the issuance of the subpoena prior to the time it was required to be fulfilled on April 14th. And now this after the fact notion of coming in and saying, gee, I got this subpoena. I ignored it in the first instance. Sorry for everybody's troubles. Sorry for all the other witnesses who showed up here on the 14th. Sorry, I've inconvenienced everybody, but now I think it should be quashed because I don't think it's relevant. It doesn't work that way. I don't get to come in and blow off a deadline for complying with the subpoena and then a couple weeks later get around to saying, I just am not going to comply. I would ask under 1317 that you hold him in contempt as we requested originally on April 14th. Thank you.
We heard a lot of talk, no facts. Let's start simply. There wasn't any email. There was a very formal letter written to the commission. Ms. Meany can show it to you if she didn't already. It's my understanding. Now I'm talking about what I've been told. I'm not able to tell you this directly. That letter was sent to Ms. Kraft with the assumption that she would contact me. The nexus of the letter, if you read it, and I'm sure you did, gentlemen, is that Mr. Reeves, Colonel Reeves, does not know who subpoenaed him. He did not get the subpoena itself doesn't have these reasons that I have that are sent to Mr. Hanneman to be sent out. He did not know anything and does not know anything about the Cavalier disciplines that are before you.
Let me ask you a question. When you say that Colonel Reeves did not know who subpoenaed him, he knew he had a subpoena from this commission, right?
Yeah, and we inquired whether who was we didn't even know who was at issue, what was at issue. You see, now he was scheduled to be out of town, and I was in court. Simple phone call from anyone could have resolved all this. Colonel Reeves wasn't trying to be in contempt of the hearing or not come.
Why didn't you file a motion to quash?
I didn't file a motion to quash because I presumed, Mr. Simeon, that I would get a communication. Actually, if you're willing to indulge me, let's be very technical. The only thing that happened involving this trooper, who Colonel Reeves has never had a conversation with, while Colonel Reeves was colonel, was a 12-hour suspension for going to New Orleans to the cosmetology school. That was not appealed by Mr. Cavalier. That is the end of what Colonel Reeves had to do, or that occurred actually during his time with Mr. Cavalier. The suspension was delegated to Mike Noel in writing and signed off on by Mike Noel, who would be the appropriate party if you were going to ask questions about that suspension. Now, we didn't know any of that when this took place. I'm not telling you that we had the intricate knowledge that we have today. We just knew that we've gotten this subpoena. We have no idea what or why or for what reason. We have no knowledge that we can share with anyone relevant to the matters before you, gentlemen. And that still stands true today. We're here. Now, according to Ms. Kraft's document she filed to quash Mr. Cavalier, a subpoena has to be relevant and the individual has to have knowledge for it to even be issued. Now, I don't know what, I'm just reading her brief. She says that's the rules. Okay. We filed a motion for today asking you to not only not hold us in contempt, but to recall the subpoena, because there is not any grounds for this gentleman to be able to help anyone learn anything about this case. If the issue of the 12-hour suspension, which occurred under Reeves' watch, is somehow being used, we don't know, but I'm projecting, if somehow that would be made relevant some kind of way to the current discipline, whatever that may be, against Mr. Cavalier, the parties, the appointing authorities in charge of that decision are the people that should be before you. Colonel Reeves can't give you any information on that. He has none, and it would, all he would be doing is speculating on the judgment of some other person that's in charge of that job now. So
I understand you said you're relying on Ms. Kraft's brief, but obviously it's pretty clear that at the time subpoena request comes in, Ms. Feeney, who issues the subpoena, will not know what the party knows or doesn't request. So she's going to issue a subpoena. She can't decide whether the person knows something or doesn't know something and then decide to issue or not issue the subpoena.
I appreciate that. What I was referring to is in the rules, I didn't have this. We didn't have this. You asked why we didn't file a motion to quash. I maybe didn't answer you correctly. We didn't know that the reasons given for the subpoena, which are on the document, but we didn't get it, or as they listed. And I won't bore you with reading them, but I will tell you that had I had these men, had I known of this procedure and known that this was the issues that they believed Colonel Reeves could address, we certainly would have very specifically, as I'm trying to do now, identified why we're of no value. You know, I don't think, I'm not making excuses, but sometimes people issue subpoenas thinking that they're going to need a witness for a reason or another reason. And they learn as they do their work that that's not going to, that particular individual is not the person you want, you know? I'm saying to you, Colonel Reeves is not the person you want on any of the disciplines that I'm aware of. And again, I'm relying on the state documents.
How do you address Ms. Kraft's point that the investigation relative to the publication of the book arose under Colonel Reeves' authority and was being done while he was colonel, and that is the issue in this particular appeal?
I don't agree that she's human right, but he's again not the right person to ask those questions to. Okay, we're just doing this, gentlemen. There's a lot of theatrics going on in all this that are unnecessary. The suspension, you know, what Reeves was involved with was not appealed, period. So it's a dead issue. Whether or not other people wrote some report about a book, do you have the report? Do we? Have we been given any information to testify or even consider knowledge of that? No. This is the first we're hearing of it. Ms. Kraft just told you that she wants us held in contempt for not being here several weeks ago. Had we been here several weeks ago, according to her, she wouldn't have had anything to say to Colonel Reeves. She learned this, she claims, watching TV yesterday. Now, I don't know what she watched, okay? I don't know what she did at that hearing, but it's not relevant to us. We don't have that evidence. We didn't create that evidence. We're not capable of discussing or opining about that evidence. We haven't seen that evidence. You know, we're here because we were required to come to answer the question of whether we were in contempt. And I'm saying to you on that issue, I asked for the deference of the committee. We tried to make communications. If that was poorly done, I'll take the blame for it. The truth is, however, that had we known what were the issues, we could have filed a valid motion to quash because we don't know anything about it. Now, if we're going to
the motion to quash based on his unavailability, your unavailability.
well, I could have filed, I suppose so, Chairman, I could have filed a formal pleading. I was thinking foolishly that if there was a problem with our unavailability, somebody would tell me, look, we really do need to have this hearing and you really need to be there. Now,
When did we get Mr. Uncle's correspondence?
It's attached to our thing as Exhibit D. It was a fax to the commission and you have it stamped received April 11th.
Our
It
hearing,
was faxed at 4:35 on Friday, April the 8th, and then Ms. Givens, when she came to work on Monday, the 11th,
and the hearing
retrieved it.
14.
was on
14.
2 days before that.
well, 3 work days, sure.
Yeah.
Okay, now, but there's not, the last thing Kevin Reeves is trying to do is be in contempt of the State Police Commission. He was colonel of the state police and he was retired with great honors after many, many years. And if we inconvenienced you, we apologize. Now, if there is going to be issue, as we just heard, then I would ask the committee to require Ms. Kraft to send us a new subpoena for whenever those hearings are going to take place and identify what is this evidence that she's referring to and give us some of it. Because Colonel Reeves is not in the state police anymore. He does not have access to state police records. He does not have access to state police proceedings. And has no idea, as we sit here, gentlemen, what exactly she's talking about. So fairness would dictate that if she believes he is a relevant witness, we get the details of what that evidence is or what she's relying on. And then perhaps, Chairman Simeon, I could file a legitimate, fact-intensive, law-intensive motion to quash, or simply appear and let Colonel Reeves give his testimony. Either way. But right now, we're in a unable to make any kind of comment at all about what Ms. Kraft just said today that apparently occurred yesterday. And obviously, whatever did occur yesterday isn't the basis for the reason she gave for the subpoena a month ago, because it hadn't even happened yet. So if we have a new reason for the subpoena, we ask for a new subpoena.
Craft, any response?
Yes. Mr. Reeves, as I understand it, testified before the legislature himself. Part of that testimony was his acknowledgement that he had received a letter written by my client about systemic racism within state police. That letter was filtered to Mr. Reeves through, I believe, Representative Jordan. In our reasons for issuing the subpoena to Mr. Reeves, we identified specifically what facts are to be proven by this witness. Mr. Cavalier did not violate policy. The discipline of Mr. Cavalier was not in good faith and arbitrarily capricious. Mr. Cavalier was disciplined in retaliation for his protected speech. Mr. Cavalier was disciplined in violation of his due process rights and civil service rules. Mr. Cavalier was not afforded prior notice and a reasonable opportunity to respond prior to imposition of discipline. The notion that there was some sort of back sent,
Now, some of the procedural issues, the discipline came
I understand,
after.
but I still am entitled to demonstrate for this body that the discipline ultimately imposed on my client was both arbitrary and capricious and not in good faith.
I understand. I was really responding to the things. about him
Understood.
Not having an opportunity to address. That would not have been under Colonel Reeves. Based on what you're telling us, you believe that
Yes,
some of the investigation may have been, and maybe there might be, and I'm not making a decision on that, maybe some of that might be relevant, but the procedural stuff that happened later, obviously Colonel Reeves can't.
he was
address.
not there in 2021.
Okay.
But I do want to note for the record, under 1313, we requested the subpoena. We identified the reasons as we're required to, and all that's required is a showing that his testimony is pertinent. You don't get to walk into any court or this body or anybody else and say, I got a subpoena, which they admit they received and were served with. and
Is there a dispute over the subpoena being served on April the 1st, 2022?
I don't think so.
The date you gave me, I can't agree with.
I'm looking at it.
Yeah, I'll accept whatever you say. As you notice, again, just reading her document, what she asked of you guys, gentlemen, and Mr. Hanneman, she put to serve Colonel Reeves at the state police headquarters in Baton Rouge, which of course he is not at. But at some point, Chairman Simeon, at some point, he got a subpoena because that's how I knew to write the letter. So we're not denying that occurred.
Is this in the record? The services?
I would add it to the record.
I'll go ahead and add. the
Well, we
services.
accept that it was.
Okay.
My final point is this. We issued the subpoena properly. It was issued under 1313. It's this commission's subpoena. We identified the reasons he was served. There was a fax apparently sent to the State Police Commission, which is noted received April 11th. There was a letter attached, which is 3 paragraphs from Mr. Unglesby. We never received it, nor were we copied with anything. There's no CC on it. There was nothing. And I'm telling you, we didn't get anything at our office. And to have this notion of, I'm just not going to bother to file anything because I didn't get this stuff and just not show up is not in keeping with the commands of the State Police Commission in overseeing state police. I get it, he's now retired, but that doesn't mean he gets a free pass from subpoenas. In fact, the rules clearly contemplate that folks who are not even officers within the state police agency are subject to both the subpoena and contempt powers. We'd ask that he be held in contempt. Thank you.
Can I ask you to do something? I think Ms. Feeney may have some information that is relevant to this notice issue.
I do think, after the facts came through, the facts from Mr. Oglesby to the commission was sent on the 8th of April at 4:35. Ms. Givens discovered it on Monday morning, the 11th, and called me. And my advice was for Ms. Givens to send it to both sets of counsel, so that they would each have a copy of the LSP counsel, Ms. Holland, and to Ms. Kraft or Brett Conrad. And I believe that was done, right?
Right before the hearing?
I mean, it would have been that Monday, the 11th, the day that Ms. Givens got the facts. So,
Is that the additional information that you want?
Yes, I just wanted to make clear that we wouldn't have known who to ask. You know, if I'd have known it was from Joe Kraft, I'd addressed it directly with Ms. Kraft.
The subpoena doesn't tell you who asked for this.
Nor that, and had I known, gentlemen, the reasons which are written down here.
Actually, it does say,
Oh.
it says to testify on behalf of the appellant, which is clearly indicated as Carl Cavalier. I mean,
I don't know who Carl Cavalier's lawyer is. Bottom line is, had I known whom it was, I'd have contacted the lawyer. So put that on me. Number two,
We accept your representation that you
Okay.
would have contacted Ms. Kraft if you knew her identity.
and the state.
And the state. And we also accept Ms. Givens's statement that she on Monday morning faxed it out to the relevant lawyers. So
Thank you. And had I known the reasons, which I have in this document now, which were not part of the subpoena, I would have been more proactive, Chairman Simeon, in identifying why we didn't think it's properly sent to us, and I'd be here. I wouldn't have been doing this today. I'd have been doing it or trying to do it at a different date when I could get time that you could give me.
And I guess that's what my concern is on this. You've been practicing law about the same time I've been practicing, maybe a year or two more. And we all know what a motion to quash is, but none was filed. None was requested.
Fine, I
other
take
than
the
a letter-
responsibility for
Other
that.
than a letter sent 3 days, well, on Friday afternoon at 4 something, and we don't get it until Monday morning for a hearing that's coming up in a couple of days. And that just gives me serious concern about why something more formal than that was not done in respect to this commission's authority.
Well, blame me. Don't blame Colonel Reeves. All right? And wherever you want to look at that. All right? I'm not going to argue with you. And what I would do in my normal life is different perhaps than what someone else would do. So that's all I can't say anything about that. You think I should have filed a motion to quash? Okay, I should have. Now, is he in contempt? No. Colonel Reeves is never intended to be in contempt, is not in contempt. And I go back, if I might, to just in considering that issue, you can consider the whole panoply of what's going on. This gentleman doesn't have the documents in this record, in Mr. Cavalier's record. Colonel Reeves doesn't have firsthand knowledge of any of the things that are before you, and is not the right person to have been subpoenaed if you wanted to get the firsthand knowledge. So in terms of holding him, I just point that out because it seems excessive, if I may, to try to hold somebody in contempt when, had they come, their contribution would have been zero. You know, so there's no harm. There's
Mr.
no
Ogletree,
point.
those are matters that you could have brought up in your motion to quash instead of today. You could have provided that information. There are two different issues here. There's the issue of the subpoena being issued and ignored. And there's the issue of the suspension and the material relevance to Colonel Reeves' participation therein. It's two different issues. We're looking at the issue of the subpoena itself. And the fact that this body issued a subpoena to Colonel Reeves and he didn't show up. And your statement a while ago about blame me, well, we can't blame you. We can't hold you in contempt. You weren't subpoenaed. So you're his representative. You've already admitted, or it sounded like you should have filed a motion to quash. You did not. So in my opinion, you leave this body with little movement or ability to understand your relevance to his being a party to, or not being a party to, anything relevant to Mrs. Kraft's case and representing her client.
Well, I didn't know if you were asking me a question. I don't want to say anything.
Maybe not. Maybe I was just making an observation. If there was something that I said that was incorrect, then please respond.
Well, no, I didn't know if you were asking me. I don't want to trespass on your time.
No, not at all. I mean, I'm just trying to summarize
Well,
what I've heard this morning. And,
Yes, all right, but
and,
let
and
me.
if I'm incorrect about something
okay.
on your client's behalf, then
Yes.
please.
I'm not saying you're incorrect. I'm trying to adjust your thinking if I'm not.
That's fine.
This issue today, gentlemen, is about punishment. And I'm suggesting to you that punishment is unnecessary and would not be called for. These matters that you're talking about, the suspension, the knowledge, et cetera, I start with, in fairness to us now, because we're the ones that are asked to be punished. They start with a good faith basis for the subpoena in the first place. That doesn't make it okay. I'm not excusing it. But I'm also, if you will, you think of mercy versus justice, okay? Their good faith basis for the subpoena, Commissioner, I'm saying it to you as straight as I can, does not exist. So in terms of should Reeves be punished for not appearing, I wish you would take that into consideration. That's all. We're not trying
Mr.
to
Oglesby,
not come here. We're here.
Would you agree, though, that if every person that this commission subpoenaed took that stance that, hey, I'm not relevant to that case, I'm going to ignore this subpoena and I'm going to send the executive director a fax that says basically to that, then this body, to Ms. Kraft's point, would be moot. We've got to abide by the rules that we're given by the state, and that is that we have subpoena power. And then when that subpoena power is used by the body, that there is a proper response. The proper response is to show up. If the council believes, as you have very well articulated, I understand your position, but that should have been articulated in a motion to quash, and then you could have made those arguments. That didn't happen.
All right, now, can I ask for a little more leniency?
Absolutely.
This is just a suggestion. This is about, I should have filed a motion to quash because I had a conflict and Colonel Reeves was on
Let me
vacation.
stop you right there.
I should have.
That's
done
not what it's about. It's about there was a subpoena issued by this body that was not followed according
I
to
understand.
the document.
thought we
Well,
were-
don't misinterpret. You're saying that it's about you're not filing a motion to quash. It's a very simple issue that we issued a subpoena. Your client didn't show up.
I was going to make a statement. If you don't want me to, I won't. But I was going to give you an idea of how you might, if you wish, address your concern about people just not coming, et cetera. And if you would, indulge me for a moment, Commissioner, in the future, I would recommend that this part here witnesses what facts will be proved by this witness, which is written by the lawyer who issues the subpoena. If that was included, it would be very instructive.
And
You know-
we appreciate your comment, and we will consider that going forward, Mr. Oglesby, but
I'm
that is not a current requirement for a valid subpoena, and it doesn't really go to the question of whether there was a valid subpoena and whether it was complied with. We agree on that, right?
Well, I'm not trying to lawyer this to death, Chairman Simeon.
Well,
But
no one who
I
can do a better
agree,
job of it than you.
I agree that a subpoena was issued, and I agree we got the subpoena. And I agree that, as all of you have articulated, the better thing to have done, rather than send the communication, was to have put it sort of in a motion to quash. Now, there, you did make you used the word valid. And that's a question I asked you. And I'm not kidding. Under your rules, a valid subpoena has to have information of what facts this witness will be expected to testify to. Now, if in fact that's included, and if it's considered, and I'm not speaking to Mr. Hanneman, I don't know how that happens. I suspect probably somebody just sends it in and asks to send it out, and that's what happens. There's no conscious thinking about, let me look at the reasons for this and see if they're legitimate reasons. But if they're not legitimate reasons, now that we have them, and they aren't in this case, then is it, quote, valid? Now, I'm not trying to hide behind the tree on this. I've taken the responsibility for it. I'm just saying that is a requirement. And since we don't, the validity word is in your rules, not mine. And it's not like, where you just send a subpoena because you have a case. It's in the rules that you have to have a valid reason. I would think that goes not only to the person who wishes that the subpoena be served and has to show that valid reason, or at least articulate one, but also would be shared with the subpoenaed individual. So he can see if that is, am I the right guy? Was I at the corner when the accident happened? No. That's all I'm asking, okay? Again, where we started. If the only evidence, apparently, that we've heard, that Colonel Reeves can speak to, if he can speak to anything, would have to do with whatever Jill Kraft is discussing occurred at some hearing she attended yesterday. Not prepared in any way, shape, or form to provide any information on that today. We don't even know what it is. So I would ask if it's easier to just do it in Stana, I don't care. We'll accept it and come back, but we need to have a basis for what is the belief that Colonel Reeves has certain evidence or information specifically to him that doesn't reside with the people who actually did it and are the best evidence, would be the best witnesses. We'll be glad to do that, but I can't do it today.
Do we have a date for the hearing on this? July 28th is the next hearing. Will you accept oral notice right here, right now, to work as the requirement that Colonel Reeves be here, unless you take appropriate steps between now and then?
Well, we'll be here. And if I take appropriate steps, I guess you'll decide if they're any good or not on July 28th. But yes, Colonel Reeves will be here on July 28th. We would ask.
Well, if, yeah, never mind.
July
I
28th.
mean, you could have argument. in
July 28th.
That's the special hearing that we set last meeting, correct?
Okay.
Yes.
So this matter is set for July 28th. We're not going to send out another subpoena to incur the additional costs. And he's under an obligation to appear pursuant to the previous subpoena based on the new date, okay?
We will do that. And I presume, Chairman, that whomever is wanting to ask Colonel Reeves about factual issues will make us aware of what they are, so that you're asking me if I can take appropriate steps. I can't take them in ignorance.
The appeal is a public record.
Yeah.
That he could review.
Right. I mean, Ms. Kraft gave you all kinds of reasons why. she
Okay,
believes
that's
it's
it.
relevant.
All right, well,
I
we'll
don't know if
accept
there's
that then.
anything else, but-
That's
The
the,
actual appeal document is a public record held by the commission, then you could obtain copies of of the whole appeal, including the predisciplinary letter and the letter of discipline and the appeal itself.
And this information that I just heard is my notice of the issue. Is that correct? I'll accept it. I just want to make sure I'm listening.
Relative to if you have some basis to argue that the subpoena should be quashed based on that, then you have notice.
Thank you.
Any other other commissions have any questions? Commissioner Knapp?
Have we solved the issue about the contempt?
No, we haven't. We'll go into executive
Okay.
session to discuss
Okay.
that later.
Okay.
Unless there's, I take it this is all the submission related to this motion
Yes, sir.
for contempt relative to Colonel Reed.
Yes, sir.
Thank you, Mr. Unser. Thank you, Colonel Reed. All right, we'll move on
Jason Turner.
to the motion with regards to Jason Turner.
You want to hear, go into executive session after this one.
You might explain to them that you're gonna go into executive session.
Yeah, Mr. Uncle speak. We're gonna go into executive session. Well, let me, y'all want to do executive session after each one? You know, I didn't think so. All right. So we're gonna go into executive session after we hear all three of these, and then after executive session, we'll come out for public discussion of what we discussed. So don't go away.
No, I'm not. I was gonna ask for something. We're coming back on July 28th. On July 28th, there'll be clarity as to why we're here. Why can't this issue be deferred until July 28th?
We'll discuss that in our executive session.
No, it's just a request.
I understand. That was gonna be part of what we would consider an executive.
All right.
All right.
Huh?
Lauren, make your appearance.
Oh, yeah.
Yes, my name is Jim Boren. I'm an attorney in Baton Rouge, 830 Main Street. I'm here as a counsel for Jason Turner, who is also present.
Jill Kraft and Mr. Conrad again from Mr. Cavalier, who is seated to my right.
Ms. Kraft, I'm gonna show you.
Thank you. Show cause? Okay. Okay. I get it. Right, okay, okay. I thought it was something.
No, this is actually.
Yeah. There's nothing before. Mhm. Right here.
All right, Ms. Kraft, you may proceed.
I don't want to reinvent the wheel, but I do want to point out again, Rule 1313 is very specific. And in this particular case, my client was suspended for 200 hours. In the letter of suspension dated October 13th, 2021, as it relates to Mr. Turner, one need look no further than the third full paragraph on page 2 of the letter suspending my client for 200 hours, where it reads, on June 30th, 2021, Captain Brad Cook informed Major Jason Turner about the association of the prior Louisiana Fusion Center email and your secondary employment application. Major Turner requested Captain Cook send him your email containing the application. Captain Cook further explained he had a conversation with your supervisor, Sergeant Flaus. Captain Cook and Sergeant Flaus had seen the social media post on Facebook and realized the association between you and Elijah Steele. Captain Cook stated he contacted Major Turner for direction on handling the secondary employment application. He stated at the request of Major Turner, he had Ms. Woodall email the application to Major Turner. Captain Cook stated Major Turner instructed him to request additional information relating to the form and request a copy of the literature from you. Captain Cook sent you an email requesting a copy of the book. Captain Cook said he did not receive a response from you. That is not the only place in the 200-hour suspension letter of October 13th, 2021 that we're here about, wherein Mr. Turner is specifically referenced and intimately involved. Again, in
I
this
don't
case,
anticipate we're going to be hearing arguments about.
well, again, this was a subpoena that was issued. I'm unaware of any communications before the April 14th hearing date. The subpoena was both issued and served to Major Turner. We identified in our request for subpoena the reasons for it, including on Mr. Turner, the fact that there are emails that were exchanged, and the addition on his is requesting authentication of emails between he and Mr. Cavalier, supervisors, of which Major Turner was one as well. In this particular instance, again, this is a subpoena validly issued. It was served. Mr. Turner simply did not show up. He is intimately involved in the 200-hour suspension levied against Mr. Cavalier, which is what we're ultimately here about, at least on level 1. Level 2 is the termination. And we ask that he be held in contempt. Thank you.
Mr. Bourne, is there any dispute that
Mr. Reeves,
Mr. Turner received the email in his email account?
yes, that's there. He did receive an email. He did not receive a subpoena, but he did receive notice that the hearing was set for that date.
And there's no dispute that that was normally the way in which individuals who were within the police service would receive notice of hearings and be required to attend.
I don't dispute that now that I have read the rules, nor does Mr. Turner now dispute that, as he has read the rules and been advised. But
Nor do we dispute that those rules.
I think I can
Nor do we dispute that those rules were available in public knowledge.
No question about
state
that.
police. Okay. All right. Go ahead then.
So I can just tell you what Mr. Turner's position is, which I think might shorten this commission's work on this issue today. Mr. Turner retired on April the 10th with 25 years of service. A couple of weeks before his retirement, he received an email from the state police concerning an April the 14th hearing. He believed that he would be retired prior to the hearing, and it was his belief that any orders from Colonel Davis or his designee became void upon his retirement, and he was an LSP employee, but now a private citizen, and a subpoena would be required. He acknowledges that he was totally mistaken in that. He acknowledges that the notice rules exist, and he believed that he should have appeared on the date of this hearing. He maintains that the reason he did not appear was because of error, not because of contempt. And he has asked me specifically to note, and I'll quote from him, that he has served previously a 6-year term on this commission as an elected member. He has the utmost respect for the commission and the important role the commission plays regarding disciplinary cases. He maintains that he never intended to be disrespectful to the commission, and he apologizes for that perception. So basically, this is not a dispute about whether he should have appeared or not. He recognizes that he was required to appear, and he was mistaken in his choice not to. He's since consulted with a lawyer who has reconfirmed his acknowledgement that he should have appeared. And so to me, there's 2 issues that I would suggest. One is, what is the proper punishment? This will come as a surprise to those of you who have not practiced law with me, but I have occasionally been late to court. And when that has happened, I have apologized to the court for being late because my garage door didn't open, or I got tied up in traffic, or whatever it is. And I believe that the punishment that I have received for that was tempered because I acknowledged my mistake and showed no disrespect, as opposed to if I were to have said, well, Judge, I didn't come here because I think that you conduct a sloppy court and you never appear on time anyway. which would be but I'm not saying that that wouldn't have been a truthful response. But I am saying that I know the better than to say that. The second thing that I recognize that there is the prospect of a fine, and that it can be in any amount. And I think that the amount of the punishment should be tempered by the intention of the party who violated the rule. The second thing that I would say is I am not aware until this morning the nature of the information that was requested from Jason Turner. I read that document this morning that Mr. Unglesby showed to me. Mr. Turner and I are both free and have no conflict with the July 28th setting for this.
You agree that no additional subpoena or notice will be.
He will
required?
accept the subpoena. I believe that some of the matters are simply a matter of identifying documents, which I believe can be done by stipulation. Now that I know what the issue is, if we can't, then we can deal with that at the time of the hearing. And if I feel after reviewing the facts more that it's necessary to file a motion to quash or appropriate, I will. But we will accept notice today for the July the 28th. And I know that Mr. Turner, I would like to simply personally apologize to the commission for not showing up. Yes.
Yes, sir. Like Mr. Bourne said, I have the utmost respect, having done the job. I think it was 2015 when I left office. I respect what y'all do and the important process that y'all play in the oversight of the state police. And I apologize for the perception that my not showing up on April 14th presented.
Thanks. Any questions? Any response?
Yes. My client has been terminated. Brief. He's been terminated from the state police. He currently works as a long haul trucker. For him to have appeared at the April 14th date with the full expectation that the witnesses would appear and we would have handled this matter meant that he canceled loads, and not just loads for that week, but loads for next week. We're here again today for this hearing in which my client advised me he also had to cancel loads. He has cleared out his load schedule for the 28th of July to come back. Why are we coming back? Because these people didn't appear in the first place. He's not only having to cancel loads to support his family, but he's also got to pay an attorney, although I'm being kind to him. But I mean, come on. He had to prepare for the hearing on April 14th. He's got to be here. He's doing a long haul trucking job, which is extraordinarily physically taxing. He takes all that time off, cancels loads, comes here, and they don't bother to show. I would ask that you would consider that. I understand apologies are wonderful. Apologies have a great purpose, but saying I'm sorry doesn't wipe out what you did. And I would ask that you would consider that in enforcing your rights and obligations under 1370. Thank you.
I have nothing to add. If any members have a question for me or Mr. Turner.
Doesn't appear, Mr. Moore. Thank you. And you do wait around because we're gonna hear the motion related to the state police, and then we'll go into executive session and come back out.
I should also say that the letter from Mr. Turner said, please consider this as a motion to quash. May I say that motion to quash is at this time withdrawn. And if we feel as though one is necessary, we'll file it at the appropriate time before the 28th.
File it with sufficient. Is there a deadline?
Well, that was the suggestion I was going to make. If you wanted to have motions to quash submitted prior to, so that they could be heard at the June meeting and resolved before the July 28th, that's a possibility.
We'd entertain a motion to set that as a deadline.
I would so move.
Second. So the motion, so it's been moved and seconded that the deadline to file motions to quash will be
June 2nd.
Didn't we already have a deadline for that?
Yes, we do.
I mean,
Okay.
that's,
This is very confusing. After our last meeting, we had deadlines for those who were present. We gave to file motions to quash. The present company was not present, so those deadlines have come and gone. So this would, if what you're talking about would be a new set of deadlines for a new hearing on a motion to quash at the June meeting. So I mean, I don't have the June date right here.
June the 9th.
June the 9th is the meeting. And so we could have the motions to quash. Let me pull up my calendar so we can.
But is that only to Mr. Turner? Because everybody else had a deadline. That's my confusion.
Well, Mr. Reeves did not have a deadline either.
He filed a motion to quash. He sure did.
So I don't know if you,
Okay.
I had presented him with the same order.
So this relates to us.
Right. So Mr. Turner, so June 9th would be the meeting. So if we could have any motions to quash filed by May the 26th and any opposition by June the 2nd.
Can you accept that as part of your motion?
Yes.
Okay. Any discussion? All in favor?
Aye.
Any opposed? Ayes have it. So, now have it.
May the 26th is our deadline for filing, and June the 9th would be a hearing on that if we had to have it.
Correct. Now, are you saying this does not apply to Mr. Oglesby and his client?
Well, he's filed his motion to quash already, right? What we're
Right.
saying did not apply was the deadline to file. We'll hear it on the night.
Okay, so your motion that you already filed will be heard on June the 9th.
Oh, all right, okay. The motion
And-
that's before the court for today is on June the 9th. And if I have the motion for the July 28th hearing, the 26th, is that? what you're
There-
asking?
But you've already filed your motion to quash. Do you anticipate needing a supplement based on the additional information you obtained today?
Yes, yes, sure,
I think
because,
what's.
and
one of
at
the-
least I gotta go listen to it, and yes, I
I
would.
think one of the things that might be confusing to you is that the last meeting in April was the original hearing date. So that hearing date was changed to July the 28th. And the motion to quash that you previously filed still has to do with the same matter, the same hearing and the same subpoena. And if you want to amend your motion to quash, it would have to be done by May the 26th, so that
Right,
it's
for
then.
the new
argued-
subpoena that I just accepted orally.
Well, it-
Okay, I got it.
It's for the subpoena that we agreed would be enforced relative to the July 28th.
Yes,
meeting.
yes, certainly. And so please tell me again my
So
deadline.
May the 26th is the deadline if you were going to amend the motion to quash,
Okay,
to add anything more. And the argument on it will be June 9th at the meeting that's regularly
all right.
scheduled here.
And so then we come back June 9th,
Yes.
and I'm gonna ask one more question. On that here, on June 9th, is Colonel Reeves required to be here, or is that just me?
I don't think so. I mean, no.
It's
just
gonna be
argument
your
on a
call,
motion.
But yeah, I mean, you make that decision, but yeah, you are required to be here to argue your motion. If you believe you need Colonel Reeves and you have him here, he's not under the subpoena power. He has not been subpoenaed or being told to come by this commission.
But it definitely July 28th.
Definitely July 28th.
That's the hearing.
Okay, all right, got it, fella. Thank you.
Well, yeah.
Yeah, unless your motion is approved by the commission, and then he doesn't have to come. Correct?
Right.
If his motion to quash
Right.
on, and we hear it on the 9th,
Mhm.
then he doesn't have to come to
Yeah.
the July 28th hearing. That's why you're coming on the 9th to argue
I
that he doesn't.
understand. Okay, thank you.
Good deal.
Motion for contempt relative to the,
I do know that they, like Mr. Reeves, filed a motion to quash in advance of this hearing, which I understand we're not now entertaining. Okay.
It was set.
yeah, we'll do that.
So with respect to state police, I think we argued extensively on April 14th, the issues relating to the non-production of documents. I don't want to reinvent the wheel, but here's what I do want to say. In response, the state sent over to my office 2 jump drives and a letter on 4/13/2022 at 1:52 in the afternoon. The hearing was the next day. In that letter, there is one reference to items 4 and 5, which are looking for the text messages and emails. And text messages and emails, again, I inserted specific terms, among which were Carl Cavalier, Ronald Green, cover-up, excessive force, book, secondary employment, business, undercover name, pseudonym, pseudonym, retaliation, assault, and battery. I identified to whom I wanted those emails, whether they had been sent or received. And the response that I got on April 13th at 1:52 in the afternoon was, as to item number 4, please find the enclosed responsive records. Of course, nothing was produced. It said overly burdensome and we could not review all requested documents. As to item number 5, overly burdensome and we could not review all requested documents. At no time was a motion to quash. At no time was there any communication to me that said, as they now apparently complain, there were a lot of documents and it's too much for us to produce, even though our IT guy apparently got them together by April 4th of 2022. And so now here we are. This is now the second time we're addressing the issue of whether they produced it. I'm not an unreasonable person. If you came to me and told me, outside of a pleading, which we just got in this case, that there's all these documents and all these emails, and we want you to pare it down, I'm happy to do so. But for goodness sakes, you don't get to show up in court when the subpoena's been issued and say, we're just not going to produce it. It's overly burdensome. You have to object. You have to file a motion to quash. It's like the horse is out of the barn and we're running after it saying, come back, come back, come back. And then the horse gets to run into another barn and argue, hey, look, there's not enough hay here. It just doesn't work that way. I mean, I hate to be silly, but come on. I mean, as I've indicated, Mr. Cavalier is out of a job. We contend he's been fired because he was speaking up about a killing. He wrote a book. He was fired for writing the book. What we asked for was very specifically targeted with those terms. If they had a problem, then somebody, for goodness sakes, tell me. But don't just show up and say, gee, we're sorry.
But Ms. Craft, we agree that relative to this appeal for which this subpoena was issued, all we're dealing with is the 200-hour suspension, correct?
The 200-hour suspension, yes, sir. But the 200-hour suspension, so you know, was a placeholder until they got the termination stuff together and fired him. That man never returned to work. And that was never the plan. But with respect to the issues that we did subpoena the documents, it is not sufficient under the Code of Civil Procedure or this commission's rules to put a little bullet item that says it's overly burdensome and we haven't had time to review it. And that's where I am. As frustrated as it seems and as frustrating as it is to Mr. Cavalier, it is a subpoena that was validly issued by this board. There is a procedure, file a motion to quash, but you don't get to come in after the fact and complain about it, especially since, according to their own affidavit, they had all those documents by, I believe, April 4th, 2022. How come nobody called me 10 days ahead and said, gee, Jill, it's a big old stack. Do you want the whole thing or do you want to pare it down to something else? That never happened. Furthermore, I'll note in their motion to quash, for the first time, they raised some notion of privileged communications between Colonel Reeves and the governor. I'm sorry, they are public officials. They don't get that kind of privilege. Mr. Reeves is not a lawyer and the governor is not acting in his capacity as a lawyer. Similarly, they raised some sort of issue about privilege among command staff. Since when? These are public documents. Again, I would ask that they would be held in contempt and at least we get the documents. If there wants to be some limitation at some other now new hearing on a motion to quash, fine. But I'm submitting to you that doesn't excuse they're not complying with the rules and not complying with the subpoenas. Thank you.
Yes, Chairman and Commission members. DPS diligently tried to fulfill the subpoena requests.
What effort was done?
On the day we received the subpoena, an email was sent over to our TBS, which is the Technical Business Support. And they sent over the search that Ms. Kraft sent to us to OTS. I have Mr. Jolie here from OTS in the place of Derek Williams, who submitted the affidavit to state that they received the request, they ran the search, and they returned it to us. I also filed with my motion the search that was done. Myself, I'm not an IT person. I received this. I didn't know what the estimated totals meant or anything. We received it on a jump drive. We had other public records requests, other committee hearings and things. It wasn't on the 4th that we looked at it. It was after the 4th. And when, I want to say, looked at it on the 11th, and our plan was to go through it. When I went through the first few emails or whatever, I was like, this is going to take more time because we have to delineate the emails that would be privileged emails and confidential emails that would have to be redacted and go through it. It wasn't, I didn't know the exact.
Normally, you know that's part of the process.
Yes. Yes.
But you waited until the 11th to look at it for the first time?
Because we had other hearings, we had a lot of things on our calendar, and we also.
Filed a motion to quash.
I never filed the motion to quash.
Commission to quash it or to postpone the hearing or to do.
I
anything
didn't. I did
to
not do that, and I did not. And I have. I'm not going to even. I didn't do that. I admit that. But we were diligently trying to get all of the information that Ms. Kraft asked for. I was in communication with Mr. Brad. Is it Brad Conrad? We spoke a couple of times and I told him, I said, we're trying to get all of the information that is needed. When I realized.
Before or after the 11th?
That was around the 11th because I received the email from him. And I also asked him, I said, well, are you going to give me copies of the recordings that you mentioned in your exhibit list? And didn't receive that. So what we did, I was speaking to him on the day of the before the hearing, and he said, don't worry about it. Just give me what you have. And so I had the latest from my office to take it to him. Yes, Ms. Kraft is right. We have the information, but it wasn't until after the hearing. I knew it was a lot. I didn't know how much it was. We contacted OTS. They met us at our office. We sat down with the IT person. I said, I know it's a lot of information here. Can you tell us exactly how much information is here? Because also we had to fulfill a public records request, I believe, from the advocate on just how much. So their specialist came in, ran through the emails that they had sent to us and said it's like 3.4 million, pages of document. I said, well, they're the numbers, people. He said that's about 7,000 reams of paper. I said, I don't know what that looks like. Can you tell me what that looks like? He said that's about 65% of the Empire State Building. At which time I said, that's impossible. It's nowhere in the world we would even be able to print all of the emails. The emails are not even printed. We were looking at them through a drive. And so we realized this.
All that's information you got after the hearing.
After
You didn't
the
bother
hearing.
to get any of that information before the date of the hearing.
No, because my goal was to provide it. My goal was to provide it. I was diligently trying to provide it. And I did not file a motion to quash, but after the hearing, I was gonna try to provide it. And then I was like, this is impossible. As far as the text messages are concerned, we had someone from our department and someone from OTS also contacted the wireless department. They said that a subpoena would have to be sent, but it would only give you information. Exact time is out. Yeah, it is 48 hours of messages. AT&T and 7 days on Verizon. And I agree with Ms. Kraft. If we could narrow it where it's manageable, then we could try it, but there's no way we'll be able to honor the items 4 and 5 on the subpoena. We didn't ignore the subpoena. We provided 1, 2, and 3. We were just unable to provide her with 4 or 5. We were not trying to be disrespectful. We were not trying to ignore the subpoena. I was diligently working, trying to fulfill the subpoena request. And I did not file the motion to quash. I thought, from my conversation, I thought, okay, I've given you 1, 2, and 3. 4 and 5 are overly broad. We don't have time to go through it. When he said, don't worry about it, just give me what you have, I was under the impression we were good. I came in here, I was completely blindsided. I'm not trying to hide anything. I didn't expect the motion to compel. My practice has basically been in district court where if it's some type of discovery, you have a conference, and none of those things happen. So I would do whatever the commission require, but we are unable to fulfill item 4 and 5. It is completely impossible for us to do.
That's relative to your motion to quash. Right now, I want to focus on the motion for contempt.
Yeah.
And why it is steps were not taken. So you say you spoke to council, we'll hear from him as to his version of that. But what is your version of what that conversation was?
Mine?
Yeah, do y'all agree on what the conversation said?
He and I spoke. I was completely shocked when I got here and he said the things he said, because I hadn't spoken with Ms. Kraft. I've been communicating with him the whole time. And mind you, I asked him for some things and.
Well, right now we want to focus on what
Yes.
you were subpoenaed to produce.
Yes, I did not produce 4 and 5. I thought I communicated to Ms. Kraft's office that we were unable to review those documents and we couldn't release them. It was overly broad. And the reason I said it was overly broad is because I knew it was a lot. When I came here, I told you it was a lot. I knew we couldn't do it, but I didn't know that lot was 3 million pages. I didn't know that at the time.
You don't mind, what's your?
Also, I'd like to introduce the emails that we do have from Ms. Holland, and specifically the one from April 11th. And this is what she told us on April 11th. We are still in the process of collecting documents. Hopefully we can make this available to you by close of business tomorrow. Also, we are waiting recorded conversation from you that were mentioned in your list of exhibits. Please advise as to when we will receive those recordings. As I understand what she just said, They had all the emails we requested on a jump drive in their possession on April 4th. I'd like to offer file and introduce the email where she
That's true.
specifically says, you'll
Is there
have
any
it.
objection?
No, that's the truth on the 11th. That's the truth.
So is that?
She said on the
Oh,
4th.
no, I received it on the 4th, but I emailed him on the 11th. The 11th was when I was able to look at that's exactly right. I was able to look at the jump drive and I saw that it was a lot of information, but
Was that email following the conversation you had?
that was before. That was before. And
So, but in the email before the conversation, you were still indicating that you were going to
yes,
attempt to produce the rest of it
Yes.
tomorrow, but that
it didn't happen. And that's when I called him back and said that we're not gonna be able to go through all of this. It's too much. That's exactly right, on the 11th, because on the 4th, when we received it, mind you, we were still producing information to the House, to the Senate. We had other hearings. We had a whole lot of things going on. So,
I would like to focus on the conversation.
okay,
that you
absolutely.
had.
Yes,
And I understand that email that we just introduced came before the conversation you had.
yes,
And then you had a subsequent conversation where he said, give me what you have.
yes.
Did he at that point excuse you from giving him the rest that you?
That's what I thought. I thought he realized, wait, our search was so big, they can't handle it. I assumed they realized that their search was so massive and it was so many documents and we weren't gonna have enough time to go through all of the documents, to segregate those documents out there that,
As best you can, tell this commission the words that were exchanged between you and he.
I called him to tell him that we are trying to get all of your information. It's right here. And that
Do you have a note of the conversation?
I don't have a note of it. I'm just going on my memory of what I said, and that I wasn't gonna be able to fulfill the request. And that, and he even acknowledged, yeah, I know it's a lot. He even acknowledged that. And he said, don't worry about it, send what you have. So I told the girls in the office to get all of the information together. As a matter of fact, they were sort of taking their time. I say, take it, take it, take it. Take what we have. They was like, well, Ms. Gay, I said, just take it. And I said, but we can't. We couldn't give over the jump drive from OTS with the documents because we didn't have enough time to go through it.
And
So,
Mr. Chairman,
Go ahead and identify yourself. please.
yes, this is Brett Conrad, representative Mr. Cavalier as well. I acknowledge that we received the email from Mrs. Holland that day as reflected, I believe it was on April 12th, and we did have a subsequent conversation. But the purpose of that conversation was not for her to explain, hey, I can't get you these documents. We were discussing resolving the matter. In connection with that conversation, she said, I still need to give you what's in subpoena. It's a lot of information. I said, well, give me what you have. At no time did I represent to her that LSP was alleviated from their document production in connection with items 4 and 5, or that she had relayed to me that, hey, we had done this search and it's coming up with millions of pages and any of that. None of that information was conveyed. My understanding was that those documents were going to be produced. And during our conversation, she did not explain to me how those documents were going to be produced. The next thing we know, late in the afternoon, we're getting a jump drive that day. And so the representation that I communicated to Mrs. Holland that LSP was alleviated for 4 and 5 is just not accurate. And I'm welcome to answer any further
At
questions.
best, you would say there's a misunderstanding of what you.
I wouldn't even say that, Commissioner. It's not a misunderstanding. I did not represent to them that they were alleviated from that. I represented to them, send me what you got, because we were less than 24 hours from the hearing. But at no point in time did I tell them that they were not obligated to comply with the subpoena or that I was releasing them from that, which I don't even have the power to do.
That's the conversation. That's true. And maybe I misunderstood him, but that's exactly what he said. Just send me what you have.
All right, thank you. Appreciate your concession on that point. Yes, sir.
So
Commissioner.
there was a jump drive that was furnished, and did that have any response to number 4 or 5?
No, it was furnished on April 13th at 1:59 in the afternoon. And it contained documents responsive to subpoena requests 1, 2, and 3.
Okay.
Yeah, 4 and 5 is the letter where it said, we're still reviewing or whatever it is.
Okay.
Yes, sir.
Thank you.
Anything else?
No,
Any brief response?
No, sir.
So that's the submission of all of the motions for contempt, if I understand correctly.
Yes, sir.
All right. So I would entertain a motion to go into executive session to discuss the allegations of misconduct.
You don't want to do their motions to quash or anything.
Oh, we're gonna do those.
I think we pretty
Okay,
much said
okay.
we're gonna do the motions
Okay.
to quash. at
All
the
of
next-
them. Okay.
the next hearing. If we entertain them.
Okay.
Okay. Would entertain a motion to go into executive session to discuss the allegations of misconduct on the part of the witnesses and the department relative to the subpoenas and for the request for that. Motion,
Second.
take a roll call vote, please.
Brian Crawford,
Yes.
Winter Nap,
Yes.
Harold Parade. Simeon.
Yes. Okay, same instructions as last time. Take you and all
I'ma
the
take
potential
my
recording
purse.
devices to the atrium.
None of them are on. There's something that came up. You
And entertain a motion to leave executive session and come back in the public hearing.
I so move.
Second.
It's moved and seconded. Any discussion? Take a roll call vote, please.
Brian Crawford,
Yes.
Leonard Knapp,
Yes.
Harold Preet, Eula Simeon.
Yes.
Back in regular session.
We're back in a regular session in regards to the matter of call Cavalier. Docket number 21257-S for any public discussion and or any possible votes. You have any motions?
Mr. Chairman, make the following motions in order that we took the cases earlier this morning. I make a motion to uphold motion for contempt and find and hold Kevin Reeves in contempt of this body for failure to abide by a duly issued subpoena and appear before the Louisiana State Police Commission at the April 14th, 2022 meeting.
Second.
Does the motion include any motion relative to assessment of any penalty?
Mr. Chairman, at this time, I would defer the penalty phase of this and the subsequent motions until our June the 9th meeting.
Been moved and seconded to find former Colonel Kevin Reeves in contempt of this body for failure to appear as subpoenaed. Any discussion? All in favor, say aye.
Aye.
Any opposed? Okay, the ruling on that particular motion, that aspect of the motion for contempt also makes moot the second. We have also on our agenda a motion to recall the subpoena and eliminate the rule to show cause regarding contempt filed on behalf of Kevin Reeves. The second aspect of that is now rendered moot. The motion to recall the subpoena will be heard at the same time as the motion to quash that was also not filed yet. Okay. When we have the motion to quash, if any, relative to Colonel Reeves, we'll deal with that at that point. Now, Mr. Oglesby, would you like us to simply consider the motion to recall as your motion to quash the subpoena, unless you want to supplement it later on as per the earlier date that we gave you?
Well, here's my question. I'm not trying to be difficult, but I'm trying to catch up. Today, we were advised and agreed that we would come back on July 28th for whatever the hearing is going to be on July 28th.
Yes, sir.
Assuming that we were, if we were unsuccessful in avoiding coming by quashing
Correct.
today. All right. The reason given today by Ms. Kraft out loud was different from the reasons in the documents that we've related to completely.
And that's why
Okay.
we gave you the opportunity if you want to supplement.
Right. So I'm going to have to listen to whatever it is she said, and then, or diagram it. And yes, we will, I will tell you, we're definitely going to move for sure to supplement, to quash all of that. I can ask another question. No, we have the right to appeal, but right now, it sounds like it's not finished. You know, it's, you've said, we think you're in contempt for not coming, but we're deferring a penalty. And also we're deferring on your recall of the subpoena altogether and whatever supplementary motion to quash there is. So arguably, everything is still in flux. So there's nothing to appeal.
Everything other than our finding of contempt.
All right. Now, if the finding of contempt, independent, you know, like ruling A, all right, doesn't require any actions on B, C, and D, then that's fine. I need to know that so I can determine whether I need to appeal the finding of contempt. Okay. But that's something I'll have to parse through. Yes, we will file a motion to quash, a supplemental motion to quash, and we'll argue whatever we've argued before, certainly. And while I'm here, might as well get this all done because you can issue all these instance subpoenas. Cavalier needs to be a witness so we can find out how valid any of these subpoenas are to Carol Reeves. So I'd ask that you require him to return.
Mr. Simeon, we did file a motion to quash on Mr. Cavalier's behalf. He was served at midnight 2 days ago. I understand he's going to be here June 9th, but I
That's what I meant.
likewise would like our motion to quash to be heard. I also want to make a point of order. Although Mr. Unglesby attempted to try to confine what I said with respect to the reasons for the subpoena, I want to make clear those are in addition to the reasons that we identified when we asked the subpoena be issued in the first instance. I don't want anybody coming in here and saying, but she said it's just the testimonies here. That's not accurate.
We're perfectly willing and agreeable, and have always been, that the reasons we've finally been given in the original subpoena are legit, are at issue. Yes, we're not trying to eliminate any reasons. We're just trying to catch up to the reasons. Now, as far as June 9th, if I heard this right, did I get an understanding Cavalier will be here June 9th?
Is that an agreement that he'll be here, or do we need to issue a
I've
subpoena?
got to talk to him, but I did file timely and in accordance with your rule, a motion to quash.
But
that-
you filed a motion to quash his attendance
did.
today.
And under, no. As it related to the subpoena, we filed it last night, served all counsel with it.
Okay.
And the way that I understand the law works, when somebody issues a subpoena and you file a motion to quash, that's kind of like, hold on. In this instance, we certainly filed it before compliance. He was given less than 15 days notice under your rules. And albeit he got it at midnight, I'm gonna have to talk to him because as you know, he's already canceled routes. This is the only way this man feeds his family.
We'll just issue a subpoena right here, right now, for his attendance in June.
And again, I'll have to talk to him. That doesn't necessarily mean that I'm not gonna file another motion to quash if I need to, or a motion to continue. Not trying to be difficult.
That's within your right, but
I
just
mean-
procedurally, the question was whether or not we need to issue another subpoena, or would you agree, unless you file a motion to quash it, that he's going to be here?
And I already did file a motion to quash, is my
Well,
point.
but you filed a motion to quash his attendance for today.
I filed a motion to quash as it related to the issuance of the subpoena.
Okay, but to begin with, our rule applies to the 16-day notice requires for parties. Kevin Reeves is not a party, so
Right.
that rule doesn't really apply.
But it does to him.
Well, but the rule that requires the party issue a subpoena with 16 days notice is what the problem is. But 15 days notice is what the problem is. But suffice it to say, all right, we are issuing a subpoena. If you have a basis for a motion to quash, we certainly will entertain that motion to quash on the new hearing date.
Understood. I just want to make it clear in this record, every single time we keep coming back on this stuff, this man can't support his family. And that's a travesty to me.
Well, I'm
Thank you,
really
sir.
sorry about that, but let's make it clear. If we're going to play rules, Reeves' subpoena that you found him in contempt of, that you claim therefore must have been, or at least for the purposes of today was valid, didn't come with any mileage, didn't come with any witness fees. If the Louisiana Code of Civil Procedure applies, he lives in Jonesboro, Louisiana, which is way more than 100 miles from here. So if Ms. Kraft has to pick what rules she wants, you know, we don't care what they are. We just want to know which ones they are.
We've had the argument on the motion relative to contempt. We've had all those arguments already. We've ruled on that motion already. Take a look at our rules. We have rules, procedural rules that are somewhat governed by the Code of Civil Procedure to the extent they're not inconsistent with our rules. But you have to pull the whole set of rules. Our subpoena rules does not require submission of a witness. But we'll leave it at that for right now.
Okay. My excuse.
Yes, yes, sir.
Chairman,
Yes, Commissioner Crawford.
enter a motion to uphold the motion for contempt to find and hold Jason Turner in contempt of this body for failure to abide by a duly issued subpoena and appear before the Louisiana State Police Commission at the April 14th, 2022 meeting. Penalty phase to be deferred until June 9th.
Second.
We have a motion and a second. Do we have any discussion? All in favor, say aye.
Aye.
Any opposed? The ayes have it.
Finally, Mr. Chairman, I make a motion to uphold the motion for contempt and find and hold the Department of Public Safety in contempt of this body for failure to provide lawfully requested documents regarding the April 14th, 2022 meeting of the Carl Cavalier matter
With the same proviso.
with the same penalty phase, correct? Yes. Oh, yes. Correct.
I would second that, Mr. Chairman.
Any discussion? All in favor, say aye.
Aye.
Any opposed? The ayes have it. I don't think I said ayes had it last time, but ayes had it on both of the motions, so both motions. There've been deadlines set to file whatever motion that might need to be filed. And Ms. Kraft, same deadline for you to file a motion to quash the newly issued subpoena relative for the June 9th.
Yes, sir. Thank you.
And Mr. Chairman, do we need to refer that motion to quash that was filed on behalf of the Department of Public Safety and Corrections?
Yes.
We need to fix that for
June
June 9th.
Those same deadlines.
At 9 o'clock.
I'll send something to all council with all the deadlines so that everybody has it in line.
I think that takes us to the end of the hearings, other than those things that were deferred to June the 9th. And so we're at the section of the agenda on the director's report.
As you're aware, the employee representative of the commission, Mr. Robert Meir, has retired. And accordingly, in keeping with revised statutes, 42-1401, actually, we proceeded with a special election that was declared on May 2nd. I made the official call of election. Yesterday, the nomination window closed at 4 p.m. and there was only one nomination submitted and qualified. So therefore, I hereby certify that Monty Montalongo, being the sole candidate after the close of the qualifying period, has been declared the winner of the special election. And the results will become official once promulgated by the Secretary of State. Mr. Montalongo will serve the remainder of the term, which will conclude on December 31st, 2026. This is my official notice pursuant to revised statute 42-1407 to the commission.
Thank you.
Mr. Hanneman, Mr. Montalongo, what's his status in the state police? What's his rank or
He
just
is
that
a-
kind of background?
Met him for the first time yesterday when he was turning in his petition. He is a sergeant out of Troop B, the same troop from which former Commissioner Robert Meir was a trooper. He's on the road sergeant, is what he explained to me.
Thank
And we look forward to swearing him in before the June 9th meeting. The other item as your custom is the expenditure report. It's been included in your binders for your review. Behind tab number 6. From the end of the fiscal year. So we're starting to see some final expenditures being made.
That you got the date
I do.
on there.
That's your request. Any questions regarding the commission's expenditures? Next, the promotional exam. We're going to conduct the promotional exam for 2022 on May 19th. So it'll be next Thursday, and we'll have a makeup the following Monday, May 23rd. And then, as promised, there is a reminder for the annual financial disclosures due to the Board of Ethics by May 15th. So 3 days. If you have not done so already, please submit those to the Board of Ethics. And then lastly, our next meeting is again set for June 9th. And I believe we're going to do a 9 a.m. start time. It appears based on the proposed agenda or potential agenda. And that concludes my report.
I take it from the lack of people in the audience, we did not receive any requests to address commission on items not on the agenda.
We did not.
Okay, we'll entertain a motion to adjourn. So move, second. All in favor?
Aye.
Yeah, the ayes have it.